Welcome to the Many Phases of Adoption, held January 11th, 1997, in Boston, Massachusetts. This is Session 3.
Great. Susan is the past Director of Education for the North American Adoption Congress in Washington, D.C. She's a contributing author for Continuing Bonds, New Understandings of Grief. Elizabeth Bartholet is a professor of law at Harvard Law School. She's on the advisory committee of the International Concerns Committee for Children. She has an honorary membership in the American Academy of Adoption Attorneys, and she's the author of Family Bonds, Adoption and the Politics of Parenting. My understanding of the format is that Elizabeth is going to speak first, followed by Susan, and Elizabeth will spend a couple of minutes rebutting or commenting upon what Susan has to say, and then we're going to have, hopefully, some time for questions.
Thank you. Our hope, although this is labeled as a debate, is not to have a debate between the two of us or even with you, but to have a discussion of the debate, a discussion in which Susan and I indicate where we come out on some of the many issues, and we also want very much to structure this as a discussion in which you all will be very active. So we have programmed our time that way and expect to be leaving something like a third of this allotted 55 minutes to discussion with the audience. So get ready, because that's what we're hoping for. Openness and closedness issues are enormously complex. There's a multiplicity of issues and accordingly a multiplicity of debates and positions on the many issues. There are many issues in part because when people say open or closed, there's a huge spectrum of openness. There are openness issues that involve non-identifying information. There are openness issues that involve identifying information, the latter being the more controversial today, since I think so many people agree that there should be at least a great deal of sharing of non-identifying information. I'm going to rely a lot on the materials, brief as they are, that I have in the conference packet, which is really an excerpt from my book, Family Bonds. And what I want to do is not, therefore, try to give you a description. I know also I'm relying on the great amount of information that all of you have as adoption professionals about these issues, the debate, the history. I'm going to try to talk about some of the issues that I see as important and significant, only a few of them because I'm limiting myself here to 15 minutes, and particularly issues that have to do with the legal structuring of adoption with respect to openness and closeness, since I am a lawyer and approach these issues in part as a lawyer, thinking about how our society is structuring these arrangements and what changes we should make in that legal structuring. I'm going to talk really about three starting points for me in terms of looking at the issues. And I think everybody who approaches openness and closeness has their own starting points, their own set of values, assumptions, values about whose interests should count for most, assumptions about what makes children happy or birth parents happy or adoptive parents happy, assumptions about what kind of family structure works the best. I think it's based on such assumptions and such values that everyone out there is deciding what they think should happen in the way of openness and closeness. There's no hard science out there, I would argue, to help us. I took a look in preparation for today at the recent, as best I can see, best empirical studies, ongoing studies of openness issues that are trying to look at how do varying levels of openness in adoptive families work for various members of the adoption triad. My sense is that those studies don't tell us anything, and the authors admit they don't tell us anything, at least yet, in terms of what works best in terms of making for self-esteem or happiness of any member of the triad. Eventually, those studies may be more informative, but we got to remember we don't do controlled studies, scientific studies very well in the business of human affairs. We don't tend to take families and say, we're going to split you into 3 groups and give one of you X form of family and one Y and then see how it comes out. So these studies aren't designed in a way that's going to give us much of a sense of cause and effect. So I think in the end, 20 years from now, we're still going to be driven back to some of our basic assumptions about values, about what we think makes for human happiness. So my starting points. One is that adoption should not be seen as a shameful family form or a shameful family arrangement. And this position leads me to a position of relative openness in terms of how we should be structuring adoptive arrangements. I think we have to recognize that legal structuring both reflects reality and shapes reality. It reflects what we think of adoptive families, and it also helps shape what we think of adoptive forms of family. So to make that a little more specific, I think our tradition of secrecy and sealed records has something to do, as I think Joyce's initial comments indicated, with the fact that there has been a lot of shame in the past associated with illegitimacy. I think there is shame today associated in many people's minds with surrendering a child to be raised by someone else. I think there's a lot of shame still today with infertility. My sense is that those things shouldn't be. It should be a perfectly okay, appropriate, and understood as a loving decision, at least when it is, which it most often is, I think, to surrender a child when you're not in a position to raise the child for someone else to raise. It should be understood as a perfectly okay thing that one opts to, or because of infertility, opts to raise a child who was given, whose birth came from another person. I think that when we surround adoption with closed records, secrecy, we've got to wall off that birth family totally. Even in your adulthood, you're not allowed to access the records. Not only does that reflect a reality that I think doesn't exist anymore to a great degree. Illegitimacy isn't seen as that shameful, unwed pregnancy isn't seen as that shameful today. But I think it also creates an unfortunate reality. I think the signal of that kind of secrecy is there's something wrong here. We have to wall off the birth family because it's a threat, because this adoptive family isn't real and valid and can't survive in the light of the sun and the presence in some form of the birth family. So I think it's unhealthy to structure adoption with that level of secrecy and closeness. Now, one thing I didn't say at the beginning, and I want to for purposes of clarification, I think we all should recognize that although there's been a tradition, to some degree still reflected in the law with respect to sealed records and brand new birth certificates, even in the step-parent adoption, there's some tradition of near total closure. Not much of it is left today. In other words, we're moving very significantly, have moved very significantly to relative degrees of openness with lots of adoptions, primarily but not only in the private or identified adoption world, but also to some degree, some slight or slightly lesser degree in the public adoption world. We're moving to lots of openness with, again, and not in all cases, a high level of openness with respect to identifying information, but it's certainly not the world it was 20 years ago. My sense is that's a powerful trend. It will be a continuing trend. It reflects some of the things that have gone on in other sort of advanced industrial nations in terms of how they structure their adoption systems. So it's not as if we should be having this discussion thinking the systematic dominant tradition today is totally closed records. It simply isn't. Now, okay, so one starting point, as I said, is I think we should be structuring the adoptive arrangement and family in a way that both recognizes this is a valid and okay social arrangement and helps make it that by opening it up, that secrecy is not what we do. We don't seal records and do secrecy. In other human arrangements, when a, divorce, for example, the non-custodial parent has no parenting rights, we don't try to seal that parent off and pretend they never existed. My sense is we should bring adoption into the realm of other modern, complex, extended family relationships as a general matter. My second starting point is that the law in the adoption area should generally focus on the child's best interests, not solely but significantly. Why? Because the child, as compared to adults, is more powerless to affect what happens to the child. Because also I think people who bring children into existence owe those children some basic minimums in terms either of nurture or providing someone else to provide the nurture. With those sort of philosophical starting points, that the law should protect the most powerless and see its function as that, and children are that as compared to the adults in these arrangements. And with the starting point that the law should protect children in part because adults owe the children they bring into this world nurture of a variety of forms. Then what? This leads me to positions on some of the issues that are very, okay, I say 6 minutes, but essential to the debate, such as what should the adult adoptees' rights be with respect to birth records? My sense is there that although now, as I understand it, only 2 states in this country recognize an absolute right of access, my sense is adult adoptees should have an absolute right of access to birth records. I think we should also move in that direction with respect to sperm and egg donors, those people who are bringing children into the world by virtue of sperm, egg, or the birth. It seems to me owe to those children willingness to be accessed, to be reached, to have contact if that's what the child chooses upon adulthood. My sense that law should protect children makes me oppose a couple of things. It makes me oppose the notion that we should resolve these issues by the typical sort of analysis, which is let's try to balance the interests of all 3 parties to the triad. No, it seems to me the law's approach should not be some attempt to do some equal balancing. Adults are out there to fight for their rights, and they are through a variety of political groups today. It's the kids who aren't. My position on children's interests dominating things also leads me to the view that we shouldn't assume private contract is the way to go. If birth parents and adoptive parents arrive at a deal with respect to openness, we shouldn't assume, okay, the thing to do is enforce that agreement. The kid isn't represented in the negotiations, obviously, that lead to that contract. Seems to me the state has a role at least to think about whether to enforce those contracts or not. We shouldn't assume private contracts between adults is what should be the rule. The state has a role in terms of figuring out what's going to be the best family structure in terms of making for general human happiness, keeping in mind the state's obligation to protect the child. My third starting point is that parents do a better job parenting than does the state. That as a general matter, we want to keep states out. As a general matter, we want one set of parents with legal rights to parent. As a general matter, it's therefore good that we have either the birth parents, or if they surrender for adoption, then the adoptive parents become the legal parents with parenting rights. I'm therefore opposed to a direction in which I see many people who are in favor of openness pushing. I am opposed to, in most cases, the state being involved in enforceable and in enforcing openness agreements between birth and adoptive families. I'm opposed to that in part because what that represents is a sharing not of information between the parents as the child grows up, but it's a sharing of parenting rights. And it's a sharing that means the state will be involved, as it is in divorced families with custody issues, will be involved in helping to run the family. If you get enforceable openness agreements, what you're going to get is people with a right to come into court and ask the state, for more in the way of visitation, for less in the way of visitation, for intervention because the birth family is not acting right or the adoptive family isn't acting right. And my sense is that both violates important traditions of autonomy, freedom that we all have in the context of thinking how we want families run, and that for kids it's not going to be good. Now this doesn't mean I'm opposed to openness on various levels as kids grow up. What it means is that I think we should leave to adoptive parents the extraordinarily difficult and challenging issues of working out when to share information about birth families with their kids, what level of openness, if any, might seem appropriate. I think that range of issues is part of what parenting rights should include. Now, obviously, there are going to be instances, step-parent adoptions, older foster child adoptions where there's a significant and positive relationship between the birth parent and the child, where enforceable openness agreements may be appropriate. So I'm talking generalities here in terms of the general assumption on which the legal structure should be built. Finally, more to say on all of this, but this man on my right here being on my mind, I want, despite the fact that this is my panel, I want to end by indicating that in my view, openness, closedness issues should not be seen as the major, most important issues in the adoption policy sort of world. I think it's unfortunate that there's the extraordinary level of attention and rancor surrounding these issues. I hope that we're going to be capable of moving beyond that level of sort of rancor and dispute and focus. Because in my view, although I think it's very important, the kinds of issues Steve talked about in terms of how the adoptive parent should raise the child, thinking about openness issues, hugely important. If you look at the millions of kids around this world growing up on the streets, in orphanages, or in foster care in this country, it seems to me the single most important thing we should be able to agree for kids is that they grow up in a loving, permanent home, and they get into that home as soon as possible. And my sense is that, therefore, the key adoption issues we ought to be thinking about as a society are the barriers to adoption, the things that make it so difficult to place those kids with the people who want to raise them as best they can, and making some mistakes along the way, but a hell of a lot better with whatever degree of openness and closure, I would argue, than those kids are being raised in foster care, orphanages, or on the streets.
Well, what I want to begin with is that records are not open. And in fact, even though what Betsy has spoken about reflects what we are seeing now as more open arrangements, the reality is that there are millions of people affected by closed adoption. And I also want to begin by disagreeing that open records are not central. In my opinion, they are central. This is a lot of work that has not been done in the past. We know much more than we did in 1920 and 1930. I also believe that Betsy is not against openness, and that she's not basically against open records, even though she's told you that she feels that a high level of openness means identifying information. And as many of you know, non-identifying information is a sketch, perhaps, that might add to one's fantasies of who the individual is, but that's all that non-identifying information is. One of the things that I wanted to do is to say that I'd like to just restate a couple of Betsy's points based on what she said today and also based on what I understand from what she's written about. The second thing is I just want to also read to you a couple of reasons why Betsy is definitely not against openness. And thirdly, I'd like to respond a little bit to the conflict that I think she has between favoring openness on one hand and not really favoring open records on the other hand. The three points I want to make that I think are of concern to Betsy, because I think that what she feels is that at the moment certain conditions have not been met which would enable us to just open all of the records. And one of them is that I think she and other people feel that the adoption movement presents a problem in the sense of intrusion on the adoptive family, a certain amount of hostility. Secondly, I think that she feels that some of the people in the adoption movement believe that biology is essential to good parenting, that the biological link is the important one. And thirdly, she mentioned today that certain kinds of openness kind of re-emphasizes the stigma of infertility for people and also about relinquishment. Now, as far as the open records and viewing adoption advocates of open records as being hostile or sort of hell-bent on getting this done, I think it's important to understand that the anger that some birth mothers and some adoptees have is really cumulative. That agencies were very well-meaning in their attempt to try to help birth mothers in the process of relinquishment as much as they could. But what we know today, we do have scientific studies. We have a lot of clinical evidence that birth mothers who were not counseled accurately or appropriately during, before, or after relinquishment have suffered tremendous amounts of variety of psychiatric illnesses. And I think you'll hear that probably this afternoon from Phyllis Silverman. And these studies are now going into their 20 and 25th years. In terms of adult adoptees and some of the anger they may or may not fear, some of them talk about feeling that they're angry because of secrets kept from them or a whole variety of things. But I think more today there's a strong feeling amongst adult adoptees that they have a civil right, as it were, to have access to their medical history. That all of you in the audience who are not adopted have access to medical history, which in many situations is life-saving. As you know, genetics and all this business is very much on people's minds, as well as hereditary diseases. But the other thing that's of concern is that adult adoptees feel that they should have the right as adults to decide whether or not they do want to have a relationship with any other adult. And whether that's a birth family or a friend or whatever, that a lot of their anger, I think I'm saying, and it's not always anger, it's sometimes just despair, is that they are being treated as children or foundlings, the very children who were to be protected somehow never grew up. And sometimes you hear people refer to adult adoptees as adopted children, still, when they're in their 40s, 50s, and 60s. Now, the next thing that I think is of concern, and I agree with Betsy about this, that biology is very powerful, and biological links are powerful. And even recently, Ruth Ginsburg was quoted on the Supreme Court as referring once again to nothing being worse than severing the bonds between natural parents and their children. Now, the trouble is, what if the birth family is unfit? What if the birth family is abusive? You've heard a lot about that this morning. What, on the other hand, if the child or the young adult becomes just extraordinarily drawn to the birth family? These are real threats for adoptive parents. There is no doubt about it. Biology is very, very strong. Now, what my feeling is that one of the problems in this is that a closed record system does not solve this reality. There are unfit people on either side of the spectrum. There are people who you all know who are biological families, adoptive families, divorced families, anybody on your block who you might think is an unfit parent. It's not something that is going to be solved by having records closed. Curiously enough, it may cause more of a problem to have records closed because, in fact, after they're closed, nobody's allowed to have any kind of monitoring of what's going on in the adoptive family. So from my opinion, you really have to ask yourself again, who is wondering and worrying about the child in a closed record system? Now, in the situation about reopening stigmas, my feeling is that it's really not about stigmas. It's really about pain and loss. And again, we have a lot of studies on this. Steve has spoken some about this. I've done research on it. We know a lot about loss, and we know a lot about grieving. And anybody who studied psychology knows that people who are unable to grieve losses have a lot of trouble. The problem I think, is brought home to me the most when you see when the losses can be acknowledged and dealt with. And I think in the most moving scenario is when you see a birth mother, her child, and the adoptive parent sit down together and try to acknowledge not only the losses that they've all had, but when you see them replace those awful losses with a feeling of gratefulness for what one or the other has done and what will be in the future. Now, that's in an open system. The reality is that with closed records, there are millions of people who do not have that opportunity. And I'm not saying they necessarily want to take it, but if they do. Many therapists will talk about giving up losses, giving up fantasies. All of you who are clinicians know that fantasies are replaced by reality, and it's impossible to give up fantasy without having reality. And so we keep coming into this catch-22 that without the facts, fantasy prevails. The example I like to give about the importance of finding out and searching for where one's may or may not have come from is that we have lots of rituals in our culture, and they're very simple. When someone's dead, you bury the body, and when someone tells you they don't want a relationship any longer, you try to get it through your head that that's over. In sealed records, that opportunity is not there. So grief is suspended. There is no grieving. You know, Bowlby once said, grieving doesn't start until the search is over.
To continue with this presentation, please turn your cassette over now.